Good morning. This is Daybreak, and thank you for staying with us. The hashtag on X is Daybreak. The SMS code is 22422 at Citizen TV Kenya, and at Ayub Abdikadir. On my immediate right is Steve Ogola. He's an advocate of the High Court. Good morning, Steve. Thank you for your time. Next to him is Faith Odhiambo. She is the Law Society of Kenya Vice President. Good morning, Faith.
Good morning.
Thank you for your time. Irungu Houghton is the Executive Director, Amnesty International Kenya. Thank you for your time. Much appreciated, ladies and gentlemen, for making time for the broadcast. Let's begin with what has been very key, as deemed by many commentators, following the presentation of two bills to Parliament, the Criminal Procedure Code Amendment Bill 2023 and the Penal Code Amendment Bill that seek to reform the country's approach to capital offences. I come to you first, Irungu, and for a very long time, Amnesty, among other lobby groups, have been championing for the same. What's the consequence if approved by Parliament?
Yeah. So good morning, and first let me just apologize because I will be here probably as long as a commercial break.
Yep.
And to the viewers also. So Amnesty has been an abolitionist movement really for as long as we've existed. I mean, over the last 60 years, we've called for the abolition of the death penalty globally. It's probably our oldest campaign, apart from the freedom of expression. I think it's important to recognize that there is a global movement towards abolition. There are about 22 countries, 26 countries that have abolished the death penalty in Africa. So we are really heading in the right direction. The amendments are actually 4 amendments to 4 different parts of our legislation. But before I go there, perhaps it's useful to just remind viewers of 2 important studies that were done by the Kenya National Commission for Human Rights in 2022 and 2023, where they found that 90% of the people who are on death row, who have been committed to death row, are undereducated, they're underemployed, and many of them are hustlers with dependents to feed. The second thing that has been really interesting, I think, from the study is that 30% of the people who were sentenced to death actually felt that it wasn't a deterrent when they were committing the crime. Right, so it is no longer a deterrent for many of these people. Many of them are first-time offenders, and therefore the question we need to ask ourselves, as 30% of Kenyans now believe, 40% of Kenyans now believe that the death penalty is no longer a useful deterrent, and 10%, actually 40% are against the death penalty, and 10% in addition are no longer convinced that it is a useful deterrent against capital crimes. The question is, why do we still have it on the books? So let me turn to your specific question, which essentially is the changes to the various codes. So there are 4 amendments. There is the Penal Code Amendment, Section 40. There is the Preservation of Public Security Act, Section 7. There is the Prisons Act, Section 69, and the Legal Aid Act, Section 43. These 4 amendments that are being brought to Parliament essentially try to strike out the death penalty and replace it with the life imprisonment.
Of 30 years?
Yeah, well, it's actually not stipulated yet, but I think as Amnesty International, we would press for 20 years. And if 20 years is not acceptable to the country, then 30 years would be sufficient. And I think the way to look at life imprisonment is not that this is locking people away for a period of time that they, for a long period of time. It is actually creating the conditions for people to be rehabilitated so that they can return to society. And for those that show no signs of remorse, show no signs of rehabilitation, then they would stay, the full length. There are 2 problems with the amendments. The first problem is that it does not, we don't have, an attempt to reform or to revise the Armed Forces Act. The Armed Forces Act has 4 or 5 provisions that continue to maintain the death penalty. So I think for us to be truly an abolitionist country, we need to go beyond the 4. We need to pass the 4 in Parliament, but we need to add the Armed Forces Act to that. And then the last one is that we need to stipulate what is the term for life imprisonment, because I think it would be ridiculous to have 400 years, 300 years, 200 years as life imprisonment. So these would be the positions that Amnesty would support.
Okay, Steve, we had this discussion here about a month ago, and now it's the judicial presentation of these 2 bills to Parliament. Talk to me about this push coming from the third arm of the government and the bearing it will have on the penal code and generally the criminal justice system in Kenya.
Now, first of all, it's not coming from the third arm of the government. The NCAJ, the National Council on Administration of Justice, is a multi-sectoral team that incorporates even the Law Society of Kenya.
Yeah.
So it's really not a judiciary-led process. But if I look at Section 32 of this bill, of the Penal Code Amendment Bill, it does not automatically decriminalize death penalty. It says that it amends Section 204 of the Penal Code and redefines death murder as first-degree murder, and the person shall be liable to sentence to death, which means, so the operating word there is liable to, which means the death sentence shall be a maximum, not a mandatory sentence, which I think is already consistent with the existing jurisprudence. And as you pointed out correctly, we have discussed the jurisprudence from the Supreme Court in Francis Muratetu. What I find inspiring and even refreshing in this, the criminal justice sector reform, law reforms, is that we have had a problem from the Supreme Court itself, which has now been corrected, and that problem is the Supreme Court appeared to have narrowed down unnecessarily the application of the jurisprudence in Muratetu. In fact, it did what it called a clarification, which raised more confusion than clarity anyway, by saying that the reading in Muratetu, which says that the death penalty is a maximum, not a mandatory sentence, only applies to persons who have been found guilty of the offense of murder. But it does not extend to other serious offenses. Now, when I peruse these proposed amendments, I see offenses that ordinarily attract the penalty, the death penalty, which now are now being clarified to mean maximum sentence. Like, for instance, Section 60 of the Penal Code, administering unlawful oaths, now you are liable to death sentence. Section 40 of the Penal Code, treason, liable to the death sentence, which means all the offenses that attracted the death penalty now don't need to be reinterpreted by the judiciary, as the Supreme Court had said, because automatically, if this bill passes, the courts will be at liberty to read those sentences as maximum, not mandatory. We have had a question where persons who have been found guilty of robbery with violence have pleaded with the courts to, because previously the offense of robbery with violence attracted the death penalty and treason, and they have pleaded with the court that, could you please extend the jurisprudence in Muratetu as a guideline judgment so that we also benefit by reading the law to mean maximum. And when the High Court started reading the law that way, and even the magistrates' courts, because robbery with violence can be prosecuted in the magistrates' courts, the Supreme Court itself came back and said, no, do not apply Muratetu to robbery with violence, to treason, and other related offenses that attract death penalty. So this is a welcome move. And I think the criminal justice actors have done a good job in terms of trying to harmonize the legislations. I think lastly, there's been a shift since 2010. What Kenyans probably have not noted, and this shift we thank the judiciary for it, the pre-2010 reality or dispensation was focused sharply on retribution, that is punishment. Post-2010 dispensation now focuses on rehabilitation. And that's why you see, even if you've been found, guilty of an offense, let's say robbery, that attracts life sentence, now they've tried to circumscribe what life sentence is, and they've said life sentence now is 30 years, which is a huge relief. Because if you have young people, someone aged 20, condemned to life imprisonment for the rest of their lives, they lose a fighting chance to get out, and they have to depend on Article 133 of the Constitution, which provides for the power of mercy, and their release is contingent on the president's exercise of Article 133. But right now, you go in knowing that you have a maximum of 30 years, which is a big relief.
As proposed. Okay. We'll talk more about the jurisprudence you have talked about of the case of Muratetu, and going forward, how this will then make the justice system, as you have talked about, more restorative and not one that punishes those who commit crimes. Faith, coming to you, talk to me about the language, because also the proposal suggests replacing terms like manslaughter with second-degree murder, and languages like idiots or imbeciles with intellectual and psychosocial disability. I mean, is this a move towards a justice system that will largely serve the society and move away from what has been living with the grip of the colonial yoke, because much of the penal code dictates as a result of a carryover from the British colonial government?
I'll pick up from what my two colleagues have said. The study that has been done by Amnesty brings into consideration the challenges that have been there, because when you look at most of these crimes, particularly robbery with violence, you see it's mostly a blue-collar crime. Mostly the poor were engaged in such crimes. And so the reality is that the judiciary or NCJ is trying to embrace the challenges that have been there. And as Steve has rightly said, most of our penal code has focused on punishment, and which negates the very essence of why we have a constitution and a civil society. Because in a society, the aim should not be an eye for an eye. It's not, the aim should not be to punish punitively for the crime, but how do we change that? This year, part of our legal awareness has focused on trying to relieve the burgeoning numbers in the prisons, because we realize we are just churning people into the prison cells. It's almost twice the number. But the reality is, how can we shift that and focus into a situation where we are looking at how can we change the narrative? How can we look at the society? How can we bring them back and rehabilitate members back into the society? Because the question is, yes, a wrong has been carried out. The justice system is supposed to change that fact by either rehabilitating the particular individual and then finding a way to bring them back into the society, to inculcate them back into the civil society. And so the challenge that has been there over time is that there's that realization that what is happening in prisons is that you're just developing hardcore criminals. You go into the justice system and you become worse than how you got in. So we're just hardening criminals. But if there was that element, and the beauty is that the law is now swiftly changing, that from the life imprisonment that, you know, there I'm in prison, there's nothing more that can happen to me. And there's the reality that the last time even the death penalty was actually effected was in the 80s. So in actual sense, you're just condemned to stay in prison for the rest of your life. There's no hope. We have seen people in prisons going to school. So what happens? You've tried to change your life. You've, you have adopted a new skill. How are you using that back into the society? So the NCJ, this bill is trying to just change that narrative to ensure that we can find a way to rehabilitate people back into the society. The reality on what is happening in the society at large. One thing that I'd say I agree with Horton is giving a clear term for the death penalty, and also maybe adopting what other international countries are doing in terms of, can we have a parole system? So that if you're rehabilitated back into the system, how can we get you back faster into the society? Because robbery with violence, you could be as good as just having a gun or even having a knife. You never really used it. But the fact is, you had a weapon. And so how can we be able, and the good example that Steve has said, a 20-year-old, how can we ensure that we bring you back into the society? We can rehabilitate you. What other kind of sentences? And that's now what we should be embracing and thinking about, what different sentences can be meted against offenders vis-a-vis now moving away from the punitive death sentence.
Okay. Irungu, coming to you, because this campaign has been all over the continent, and for example, the list of the countries, only 4 in the continent carried out executions. Botswana, Egypt, Somalia, and South Sudan. That is in the year 2021. But here at home, also part of the proposal contained in the bills is the removal of the presidential pleasure doctrine, which previously stated that persons unfit to stand trial were detained in prisons at the pleasure of the president, i.e., for example, until the head of state chooses to release them. The courts have for a long time held this is unconstitutional. How relief is this, and is it a walk away from the previous position to a more now position where power is exercised as the Constitution requires?
So I think the power of mercy, the concept, it's a global tool that's used. I think the concern has been really that in many ways it has been used to release persons that are close to the president or have some relationship with the president. And I think we've seen this particularly in the case of the United States, where Trump released, or rather pardoned, several people of his administration from economic crimes and various other crimes. And I think the concern has been that really it should not be the prerogative of an individual. I think we've seen in the last few months the President Ruto has actually revamped the Power of Mercy Committee. There was a bit of controversy, I think it was 3 months ago, where a number of people who were released seem to have been released prematurely. So let me stop there. But I think the point that Faith raises, and Steve has alluded to it also, is the importance of seeing people who come before our courts and who come to prison as persons in distress. There's a wonderful circuit judge in the United States called Victoria Pratt, who some of the viewers may want to follow up on. She talks about transformative justice. She says everybody who comes to my court is a person in distress. They are in conflict with the law. And therefore, the first thing to do is essentially to establish, first of all, whether the crimes took place and therefore pronounce guilt or not guilty. But secondly, to begin to look at how do you start the restorative justice process. It doesn't just happen in the courtroom. It also happens in prisons. And I think another area that I think we can now look at, now that we have gone beyond simply the idea that serious criminals should just be locked away for life or sentenced to death, but we don't commit the act, is to begin to think about post-prison care, halfway houses. Yeah. What's the investment in that as well? But I think coming back to this issue, 79 men and women were sentenced to death last year. Right, despite the fact that we have not executed somebody, or Kenya has not executed somebody for 40 years. And therefore the question we need to ask is the judicial system in line with the executive decision not to execute? And I think this is why these amendments are so important, and why Kenyans need to support them, and the parliament needs to essentially pass them, is to ensure that there is a framework that is much more restorative rather than punitive, I think as Steve has talked about, and then more importantly, I think, to look at what are the aspects of the criminal justice, the penal justice system that need to reform as a result.
And given that for a long time your quest was a clear definition of life sentence, the proposal in the bills is 30 years. I mean, is this a course that you pursued? I mean, and you talked about 20, but given that this proposal is saying 30 years, what level of engagement has been done in engaging the civil society, one of which you head here in the country as the executive director, Amnesty International, and do you think that is what you had in your thought, for example, the campaigns that you pushed for a very long time?
So it's completely consistent with the work that has gone into campaigning for the abolition of the death penalty, not just by Amnesty, but ICJ, by Law Society, various other organizations. The International Commission of Jurists released a report on World Death Penalty Day, where they pointed out that quite a number of the cases that are death row prisoners actually involve victims of gender-based violence. These are people who killed an intimate spouse, in some cases in a context where they were there was ongoing conflict between two parties. And I think the question is, and many of them are very young, they're in their 20s. So the thing that we have to get is that actually there's a lot of tension in the society, there's a lot of violence in society, that simply condemning people to more violence doesn't actually resolve the problem. One of the interesting statistics I've always found really instructive is that countries that have abolished the death penalty have not seen huge spikes in homicide. They've not seen serious crimes escalate as a result of removing the death penalty. And I think that's an important argument that we need to keep in mind, that it's not the case that once you remove the death penalty, you will suddenly see crazies all over the country committing serious crimes. And I think that's encouraging for us.
In your view, then, one final question. Is this, from your understanding, an observation throughout the year, because the dispensation we have, Constitution 2010, is termed as one of the most progressive, eloquent and expressive constitutions admired globally. Is this one of the progressive nature that it came with. I mean, and the interpretation here at the judiciary and the conglomerate of other organizations, including the civil society, that now there's a clear definition to that effect, and which that seeks also to reform our criminal justice procedure.
Yeah, I would affirm not just civil society, I would affirm the actors within the National Council on Administrative Justice. I think those actors have played a big role in this. I think the judicial officers, there's a lot of support for the abolition of the death penalty within the prison service. A number of investigators and police officers and prosecutors think that this is an outmoded colonial practice that we have retained for far too long. You know, it was, you know, I think it's the last time that we actually executed somebody was just under 40 years ago, right? So I think the question we need to ask ourselves, why do we retain a tool that we have not utilized and have not seen the benefits of for 40 years? There is nobody employed in the government of Kenya anymore to hang people. Right, the square in Kamiti where this used to take place, and where, you know, I think it's topical to remind ourselves that, you know, somebody who was, you know, a victim of a death penalty was Dedan Kimathi, the first Prime Minister of Kenya, if I can be a bit historically provocative. Yeah. You know, we have many of our shujas were actually executed using this particular penalty, and I think this particular law, and I think it's important that we abolish it immediately. You know, one last comment. It was, you know, when Peter Oko and Wilson Kinyua, if I give just two examples of, and Faith reminded me of these two people, you know, when they were accused and sentenced and convicted of serious crimes, you know, they went into prison and were condemned to death. They spent their time in prison learning, studying, and came out with law degrees. And actually, both of them have come out of, you know, they've had their sentences commuted. They've come out of prison, and, you know, both of them are working with young people now to actually reduce the levels of crime and the numbers of criminal gangs. So I think it is possible to see this, you know, these amendments essentially giving rise to another culture, which is a culture of rehabilitation, restoration, and also generating capacities and resources that bring down crime. And I think those two individuals are the best examples of people who have done that.
Okay, thank you. And when we get back from the break here on the broadcast, we'll also talk about the other aspects as contained in the bill, including the customary and Islamic law and the recognition of polygamy, the phraseology therein, and manslaughter is now gone according to the contents of the bill, the operation of the word liable to meaning maximum, not mandatory, and also aligning with the Murwatetu jurisprudence as mentioned by Steve here, and Faith as well, and also the Executive Director of Amnesty International, as we at length also take a look at the state of the judiciary annual report, which was released last year by the Chief Justice Martha Koome, and which was also attended by President William Ruto. One of the taskings that he undertook less than 24 hours after he came to office in September last year was swearing in of the judges who are rejected during the tenure of President Uhuru Kenyatta, and by extension, of course, the reforms needed in the judiciary, and why there are many cases that still remain unresolved. The hashtag on X is Daybreak. The SMS code is 22422 at Citizen TV Kenya and at Ayub Abdikadir. The discussion continues after the break here on the broadcast. Stay tuned.